Loving the Divorce Podcast? Take it further with Amicable Space, our exclusive membership for people navigating separation and divorce. Get expert webinars, exclusive content, a supportive community, and our Amicable Extras podcast with extended interviews and expert insights. Join today at amicable.space/membership because the right support makes all the difference. Welcome to the Divorce Podcast, where we explore all aspects of ending relationships, separation, and parenting apart. If your marriage or partnership has ended, or you have friends and family who are separating, this podcast is for you. I'm Kate Daly, a relationship counsellor, divorce specialist, and co-founder of Amicable, the online legal service for separating couples. In each episode, we look at relationships and separation from different angles, including the emotional, legal, and social. I'm joined by experts and special guests who share their own unique stories, experience, and tips with the goal of helping people end relationships in a kinder and better way. In this episode, I'm joined by Stephen Wildblood to discuss non-court dispute resolution, or NCDR as it's known. We start by unpacking what NCDR is, the main types available, and the key benefits of choosing this route over going to court to finalise your divorce. From there, we explore why NCDR isn't as widely considered as it should be, and discuss simple ways to raise its profile with the public. Stephen shares how his plays are helping to shine a light on NCDR and why this creative approach is such an effective way to spread awareness. Finally, we look ahead, imagining other ways to reach a wider audience and ensure that non-court dispute resolution becomes the go-to choice to untie the knot. If you loved this episode, then please subscribe and rate us on your preferred listening platform. So thank you very much for joining me, Stephen. If we could start with just some basic understanding of what it is we're going to be talking about today, and that's non-court dispute resolution. So what does that mean, and what sort of activities or what sort of types of non-court dispute resolution exist?
Well, non-court dispute resolution really means what it says on the tin, that it is any means of resolving family issues without going to court. I think people often say that there are four main types of non-court dispute resolution. I think that is somewhat limited in its perception. There are a number of other forms of NCDRs, we call it, besides the four I'm going to go on to mention. And I know that you in Amicable are offering a different form of NCDR that is of particular value. People think about the four main types, which are arbitration, mediation, early neutral evaluation, and private FDRs. But certainly I'm working in a different form of mediation with Dr. Frida Gardner. And so I don't think it's always helpful to just try and pigeonhole all types of NCDR within the four that I've described.
Let's go on then to talk about the different forms of non-court dispute resolution. And there's a lot of terminology about those different ways of doing things. So I want to be able to explain some of that as well on the podcast. So the first sort of acronym to debunk, if you like, is NCDR, or non-court dispute resolution. So let's start with that. What does non-court dispute resolution mean in practice? And what are the main types available to people who might be divorcing or trying to sort out children's issues in England and Wales?
Well, I suppose it means any form of process that leads to people sorting out their family issues without going to court. Arbitration involves the couple agreeing to appoint a specialist and trained lawyer who acts as an arbitrator in accordance with the Arbitration Act. And it's a bit like paying for a private judge, I suppose, because you put before the arbitrator a specific issue. So how often, where the children should live, where they should go to school, how often they should see both parties who are separating. And the arbitrator applies the law of England and Wales and gives a written decision, having heard evidence and having read statements and other documentation. So it feels very much like going to court. Mediation involves asking a neutral and independent person who is trained in mediation to facilitate discussions between a separated couple with a view to them reaching an agreement as to how their children or finances should be sorted out. An early mutual evaluation, it means you go to a lawyer, you choose a lawyer, a specialist in an area, children or money usually, and you ask that lawyer for an indication about what would happen in that lawyer's opinion if you went to court. So it's a way of really nipping things in the bud at an early stage and getting a strong steer about what would happen if you went to court. And a private FDR relates to money cases where once a case has developed and there's been an exchange of information, financial disclosure, you go to a chosen lawyer for that lawyer to help you and your legal teams reach a decision together. And they work. Most cases sort themselves out without the need for going to court if you take one of those 4 ways forward.
And I can't let you get away without saying that there's obviously a fifth route from our perspective, which is to use a service like Amicable, where it's similar to mediation. You work together with an independent specialist, but we do all of the legal paperwork, unlike a mediator as well. We work one-to-one as well as with you in a couple too. So there's a couple of key differences, but essentially it's a similar kind of process where we're trying to avoid having people end up in court over sometimes quite small issues and not huge sums of money. And I guess that's the key, isn't it?
I think it's really interesting what you're doing, because I think there has been a tendency almost to pigeonhole the types of non-court dispute resolution, NCDR, into those 4 categories that I've mentioned. And I'm really interested that you're working outside the box. And I think that there's a development that is going on, that people are realizing that you can't just push the answers into one of those 4 compartments. The work I'm doing with Dr. Frida Gardner is a different form of NCDR, and there are other forms of NCDR that I'm using as well, and I think they are very effective. So the work you're doing is really important, really valuable. Thank you.
Well, I think you're right. I think there's been there's been a very broad development of different types of services, and people are taking on feedback from customers and clients as they come and working out what works and what doesn't work. And we've got many more options. And obviously, as technology starts to play a role in some of these solutions as well, I think there's a real opportunity to find many different creative ways of solving these problems and to bring costs down as well. Because obviously, when you go and sit with 2 very highly trained professionals, your costs start to escalate very quickly. And for lots of people, there just isn't the scope, the resources, or the desire to spend such a huge percentage of the assets on sorting out a solution. And I think that's really what's driving some of this is consumer choice, technology, and the desire to have a proportionate response. And when I think about the judgment that we got from the High Court, that's what Mostyn said. That was his big point, that you need services that offer proportionate kind of solutions, because yes, you can go in front of a judge and you can go all the way through all the different hearings. But if you're talking about the average assets of most people in this country, it just doesn't warrant that kind of intervention. It's unaffordable. And you're talking ultimately about a whole bedroom or a whole postcode or a garden or not a garden, or, the end of private education for children. They're big choices people are having to make if they're going to spend that much money. So I think you're right. There are a whole bunch of new and exciting ways of sorting these things out coming on board. And it is down to people like you and I guess us to sort of try and make a creative option for people where the old ways of doing things just don't seem to fit anymore.
I think people are becoming much more aware as well of the need to avoid the cost, as you've mentioned, the incredible delays that can occur. But also, I think there's a growing realization that people want to be kind to each other. They don't want to be so nasty to each other as litigation can avoid, because essentially litigation is still conducted within an adversarial mode. And when a couple splits up, they're having to deal with the difficult emotions that arise. It's probably one of the worst times of their lives for both of them and their children. And the idea that they should then go to court to seek to validate their own opinions against somebody who they once loved is really very difficult. And people increasingly are wanting to turn away from that. And I think that's entirely right. So the work that you're doing and the name that you've given to it resonates, I think, with how many people want to deal with their personal and private issues.
Yeah, I mean, that's a good point that you raised, the issue of privacy, because recently, as you will know better than I do, the rules on privacy have changed. And so now many more judgments are being publicised, and the right to anonymity is no longer guaranteed, is it? Because there's been a lift on the reporting ban in family cases. So it might be that your case is reported. And I think that's probably having an impact. Have you seen, and do you feel there's an impact from that change in legislation?
I think it's really important to understand what is happening, because there is still a requirement in almost all family cases, certainly concerning children, that the anonymity of the children and of the parties is preserved. So I wouldn't want people to think that if they go to the family court that they're going to have all their personal details plastered across the local press. They're not. The transparency movement is not intended to leave a free license to the press to report the sensational aspects of people's separation and that salt into the wounds of their misery. That's not what it's there for. What the transparency movement is trying to do is to ensure that there is a greater public understanding of how the family court operates. But I do think that when many people would feel extremely uncomfortable about going to a court, a strange building, which is a public building, in front of people they don't know, in front of a judge, they don't know what the judge is going to be like. They have lawyers poring over their private details and using those private details for cross-examination in courts, turning their most sensitive family issues into the subject of legal scrutiny in a court environment.
But it is worse than that, though, isn't it? Because just to pick you up on that, Stephen, recently there was the case, I won't name, but its name is out there, where it was the energy executive, the founder of one of the big energy companies, and all of their case was free to be able to see. And I know exactly when they stopped having sexual relations, for example. That's an invasion of privacy of the absolute highest order. So you do risk, by going to court, things like that being out in the public domain. That's out there. I've read that perfectly legitimately, and anybody else can go and read that case and know exactly when that couple stopped having intimate relationships. I think that is a risk to people, and I don't think that people understand that that kind of stuff can be reported, and that's what you risk when you end up in the court system.
Yeah, I think that's a very specific case. And there are, of course, some financial cases where the anonymity is not given. And I accept that can be perceived as a risk. It's a very difficult balance. What the legal balance is between Article 8, which is the right to privacy, Article 8 of the European Convention, the right to privacy, or right to respect for privacy on the one hand, and Article 10, the right to freedom of speech on the other hand, the ability of the press and of society as a whole to see what is being done within the domain of a public institution such as the family court. And that is a balance that's had to be struck and has been struck, I think, very carefully and very correctly because of the need for the public to see what is being done in their name in a public institution.
But you are right. I think whilst the privacy element is one bit of it, the other bit of it is the emotional trauma of spending months and months in the court system. And like you say, going to court, the experience of that. And we had a session the other day within our team about what it's actually like. And even down to very small things like there being no water available, the toilets out of order, nowhere to sit, no windows in a lot of these places. And if you're there, day in, day out, having to go through airport style security, not knowing where your barrister is or what they look like, or not realizing that this isn't how you see it on the telly when everybody's very, amazing and everything works and it's all very glitzy. It's nothing like that. This is really a very unpleasant experience. And that's not to undermine the very valuable work the court does, but just to say, I think there's a misconception from the public that you sort of go to court, it all gets sorted out, it's all done in one hearing, right is the champion, and your ex or you are told this is how it's going to be and off you all go, and that's the end of it. And I think that what we have to get better at is explaining that that's not how the court system works. And for most people, they're not trying to resolve legal points, they're resolving emotional points in a legal context. And I think that's where sometimes the NCDR, the non-court dispute resolution process, has so much more to offer, because I think most non-court dispute resolution processes try to tend to that emotional journey as well as sorting out the practicalities of what's going on.
I think there are obvious advantages to NCDR. It's not just that it undoubtedly saves money. It does reduce the delay, because certainly in the cases that I've done in arbitration, the case has started and finished within 10 weeks. And you could never do that through the court process. But I think also you can choose your venue, you can choose your time. And importantly, the most important of all is you choose who's going to decide your family issues. And I can't emphasize enough, I think, how important that is. For me, as an arbitrator, for instance, I can spend as long as I want preparing the case. And that is a real luxury.
Isn't it? Yeah.
Yeah, it really is. So I can spend, a day or two preparing for a case, or longer if it needs it. And afterwards, I can spend as long as I like writing the decision to make sure that I express it as I would want it. So I think there's a real quality of service that can be provided. And mediation has developed considerably, I think, over recent years. And there are a number of different types of mediation. So you can have what's called lawyer-assisted mediation, where your legal team are present with you during the mediation, so that if you need support, then the lawyers are there, and it can help even out the playing field if there's any inequality in the bargaining power between the couple. So things have moved on considerably.
I mean, I think we're making a great case, aren't we, for NCDR? But why doesn't everybody do it?
I think there are a number of reasons. I think, first of all, I'm not sure that we who work within the NCDR system have been strong enough to get into the community, to explain what we're doing to the community. So I go to lots of conferences, for which I'm very grateful, but they are conferences about mediation populated by mediators, and conferences about arbitration that are populated by arbitrators. I really think that we need to get out into the community more to explain what we're doing so that people see us and understand it. That's the only way, I think, in which we're going to diminish the court-based culture. So people separate, there's a row, things are not easy when you separate, as anyone will know. And it's very easy for someone to say, right, I'm off to court. And unless there is a very strong deterrent, one way or another, notwithstanding that there's this thing called a MIAM, people find a way to get their case into court. And once it's in court, it's very difficult to get it out. So that's point one. We really need to help people understand what NCDR is. And that's why I'm really grateful for this opportunity. I've studied this quite a lot and looked at how different countries approach this issue. And I may be in a minority, but I think that we haven't yet developed a strong enough procedural approach to require people to inform themselves about NCDR before they get involved in court litigation. In some countries, Australia, for instance, there is a requirement that you attempt mediation or NCDR before you apply, unless there are certain exemptions. In this country, at the moment, only the applicant is required to attend a MIAM before issuing a court application. A respondent is expected under protocols to engage, but there's no requirement for that to be done.
So if essentially you mean then if one person refuses, that's, without any document or paperwork, if you're the respondent, you just point blank ignore or refuse, then there is nothing you can do about it in this country at this point. You have to end up down the court route, you mean?
Yeah, there isn't a requirement for people to engage in NCDR before they access the court system. Now, there will always be some cases, for instance, those involving domestic abuse or other specific reasons why a couple can't go to NCDR. I'm not talking about them, but I am talking about people who could engage in NCDR but are not sufficiently informed about it, or get swept into the court-based culture and find themselves in court. And I think as things develop over time, we will get stronger on that. But it's part of the reason why NCDR has not taken off as it should. The other reason, of course, is expense. I mean, some people just don't have the money. That's quite interesting because I've, along with others, have said that I would be prepared to work as an arbitrator, for instance, pro bono, without a fee, in a pilot scheme to see how that works. And it's taken us ages to work out how that is done, how we would get safeguarding information, for instance, about the couple, which is essential. You need to know if there are convictions or if there's any other safeguarding issue that means that a couple should be required to go to court rather than come to arbitration or other forms of NCDR. Even though we spent months doing that and we've spoken to quite a lot of people about it, as yet I haven't had a single pro bono case. And getting into the system, getting people to alter how they practice is hard work.
Arbitration to me in particular seems like such a no-brainer, particularly if you've tried other NCDR routes and come to an impasse. If you're mediating or you're doing our system or something, and then you get to a point where there's a point you cannot get across, the ability to go and resolve a very specific point rather than have to throw everything back up in the air seems very, very attractive. But like you, we have never been very successful. We only have 5% of our cases that don't resolve, so we have a 95% success rate. But in that 5%, we've tried very hard when they haven't resolved to get people to go to arbitration and finalise, but people don't. And I can't, especially when they've been through that whole kind of working together as a couple, they've set goals, they know the bigger picture, they're committed to trying to have a post-divorce relationship, usually because they've got children and therefore a very important reason. But just trying to get them to take that step has been nigh on impossible. And I know that we're missing something and I can't quite put my finger on what it is or what drives people back into the arms of two separate solicitors, and whether that's something that's a very psychological kind of feeling of wanting protection, wanting someone to fight your case, whatever it is. But I can't quite get to what's not working, because to me, logically, doing this, it seems the absolute logical next step.
I agree. I think it's educational more than anything else. I think getting people to change their system of working is really difficult. It's much easier to follow procedures that you've always followed rather than to change them. And if you change them, of course, you feel there's some sort of risk in affecting the change. So people just stick to the procedures that they are used to. But I absolutely agree that the thing about arbitration is that if, for instance, let's say you mediate and you can almost agree everything, but you can't agree on a point. You can agree the children are going to live with, let's say, their mother, but you can't agree on the precise details of how much time they're going to spend with their father. And you're then left with the option of going to court and it taking weeks and costing lots of money, or you could go to arbitration. Well, you can go to arbitration on a single identified point. In finances, for instance, you might agree all the capital division and the property division, but not be able to agree on whether there should be what's called a clean break, whether one party should pay the other maintenance, and if so, for how long. You can refer that point to arbitration rather than get involved in the court process with all the problems. You can refer that to arbitration.
Well, also the court process would potentially unpick everything that you've already agreed up to that point, wouldn't it? So a court doesn't, when you go back into the court process, the judge is looking at everything from scratch.
Yes, although if you say to a court, these are the agreed, we've agreed all this, we just need a decision on this point, it is likely that the court is going to respect that. It just takes a long time, and you're then in the court process if you choose to litigate. If you go to arbitration, the arbitrator is fixed to decide the point that you refer to arbitration. That's the deal, the arbitration deal. So on the clean break example, the only point for the arbitrator to decide is the point that is referred to him or her by the parties. So you keep control of what is going on if you go to arbitration. This is the point we can't decide. We choose you to decide that point.
Well, this is kind of the point where you can put your other hat on now, because I think one of the big things about all of this is it's just not in the public imagination, is it? It's not out there. People don't know about this. It sounds very fringe, and it's not. It's totally mainstream, and yet we don't yet have a way of communicating about this. Like you say, when you go to conferences or I speak, we're speaking to our own kind. And that's not the audience. The audience is people out there who next week one of their partner will say to them, you know, this is at the end of the road for me. I don't want to carry on. It's those people we need to reach. So I'm really interested just to explore a little bit about the other string to your bow, which is the playwriting you do and how you're trying to bring to a completely different audience some of the kind of ins and outs of how disputes in family cases are settled and what it's like to be involved in that. So tell us a little bit about your writing.
I write plays about sort of social issues that lie behind the cases that I see. So the play that we're running at the moment is called Deadly Through the Looking Glass. It involves a couple who really loved each other when they started, and they had a child, and slowly their own psychological backgrounds and the system itself pushed them further and further apart until there is a court case in which Dave, the father, is told he's not going to be allowed to have any direct contact at all with his daughter. The play is written in a reverse chronology, so it starts with them meeting again 25 years after they've separated, and just expressing that deep sadness and regret about what happened. You know, how did they end up that way? They spent the 20 years since they separated, really giving up on life, and they've had opportunity to think back to how they were when they started, how much they each meant to each other, and the bewilderment, I think, that many people feel. How on earth did we end up in that way? And I wanted to start the play with that message. Really think hard about where this is taking you when you are splitting up. Separation happens. We've all had separations, I'm sure, in our lives, and they're really painful, but don't get swept along by the system. And so what I'm doing, I'm working with really wonderful actors. And I'm going to give them a plug, so, and forgive me for doing that, but it's a really brilliant team. Jacob Crossley, James Evans, Carly Norris, and Lauren Comet. We sort of got together And we thought we really want to do this. And so we've gone on and done it. And it's times quite challenging. It can be quite frightening. We find ourselves in all sorts of places performing in front of all sorts of audiences. But together we've put this on. And I think that the idea is to show the issues, show, don't tell, show people what the issues are. And what we do afterwards is either the actors, myself included, remain in role and we take questions from the audience and develop the story through the questions that are posed. Or else, in the Daisy play, we have in the past taken the story back to the point of separation, that the couple, Dave and Maggie, played by the actors in the team, stay in role, and we have a mediator, a trained mediator, unscripted, running a mediation with the couple. And invariably, when we've done that, some contact has been devised. So the father has not lost contact with his daughter. I mean, it is totally unscripted. You know, you just don't know what the actors are going to say, and it's all down to the mediator's skill. But invariably, a way is found which is far better than what happens in the play when it goes through the court system.
If we do this kind of the public debate, we get more involved, we find ways, as you're doing, of showing, not telling, that all bodes very well, doesn't it? And hopefully at some point, somebody from EastEnders or one of the other big soaps where they've got a massive audience will come and see this play and will realise that that needs to be part of their storylines. But how do we reach more people then? I think you've got a book coming out, haven't you, as well, Stephen, which I guess aims to reach more people as well. Tell us a little bit about that.
It's a book that I'm writing with Dr. Frida Gardner, with whom I'm working. She is a consultant clinical psychologist. She and I have set up an LLP together to provide a different form of NCDR. So we work with couples, both of us together, to try and help them resolve children and money issues. And the idea is, because of the psychological input and I've been a lawyer for 45 years, so I'm afraid whatever I bring to the party, together we work with people and with a view to leaving them intact at the end, as well as having their problems resolved. It sounds rather as though a way that's similar to the way that you are working.
Exactly. We see the emotional journey as the actual guiding factor for all of this to resolution. So we see this as an emotional issue with legal and financial consequences. So we focus on the emotional journey, and the people, all of our divorce specialists are trained in that emotional journey, and they know how to help people move through the different stages. They understand the difference between whether you're the instigator or the person who's been told, or whether you're coming at it as a more mutual decision. So it's about understanding those psychological profiles and then resolving the issues and making sure you're staying within the bounds of English and Welsh law. So it sounds like we're sort of agreeing that emotional lens is a really important one to capture when we're talking about resolving family issues, rather than just focusing on the legal angle, which I guess has been the traditional way of doing things.
Yeah, and not approaching it as it's sort of what I call the nuts and bolts way, to really understand the couple and the family as a whole, to help them move on in their lives, and they still remain a family, even if they're separated. Especially, with their children around, that there are complex family relationships that are going to go on for the rest of those children's lives, and how people behave at the time of separation will set the standard for years to come. So I know that I don't have anything like Dr. Gardner's skills with people. She's been a clinical psychologist for years and has an ability to understand people's behavior in a way that I don't possess. It's not my training, but it's not my aptitude. I can, however, provide input based on 45 years as a family lawyer and as somebody who's taught this, in fact, as a mediator and practiced as a mediator and an arbitrator. So that combination, we think, is an important one, as no doubt you do from the description of the work that you're doing.
And I think that's similar to some of those other models you were mentioning before, like in Australia. But I guess what the Australians have that we don't yet have in this country is the infrastructure around the different services. So someone's got to find your service or find our service, whereas I think some of the other models, it's baked into the way the whole process works. And I think that's possibly the shift that we are maybe longing for and looking for in this country, isn't it? And I know there's some very interesting experiments going on at the moment with family hubs and that kind of thing, but a place that you can go to if your relationship breaks down that can give you the guided tour of all of your different options and provide people to help from any which of those different NCDR options that you want to pick from. So like a proper menu, and being able to match your circumstances to the process that's likely to work best for you is, I feel, quite important.
Yes, I think also people can get, it must be overwhelming when you're dealing with all the sort of crisis of family breakdown, and then you have so many different things flying at you as, why don't you try this or that or the other? I just think that clear explanations are so important to help people at that time. And if you don't catch them at the right moment, then they're going to make the decisions because they don't understand what the options are. So that's why I'm really keen to explain things. And one of the things I've been doing is I'm really fortunate to have joined a set of chambers that is as progressive as the one I have joined, 3PB. And they are doing things like films to explain arbitration and are really supportive in getting this message across, not just amongst the lawyers, because the lawyers understand it already, actually getting into the community to help people to understand what it is we're doing.
I think that's another important route, isn't it? And in the same way, your book or your plays, you're not expecting just people who are in the system to come and watch them. They are there for entertainment, to try and educate people just in case. And I guess that's the key thing. And it sounds like the films that Paper Buildings are doing and all the rest of it, that's part of this movement, isn't it? To try and change and shift the narrative around divorce and separation. Because for me, that's one of our absolute core business objectives. Yes, we've got sort of commercial objectives, but our main objective is to shift and change the narrative, because if the narrative changes, people will follow. And that's really key.
Yeah. And also, separation affects children. And in the work that Dr. Gardner and I have been doing, we've spent quite a bit of time researching how things are done in Scandinavia. I've been particularly interested to see how things work in Denmark. And there, they always see children in their court process from the age of 6, unless there's a good reason not to. So that is part of the work. And judges work with child experts in, and I'm not going to be able to say this word, in an investigative, that's the word I have found difficult to enunciate, but that's their process. It's an investigation rather than an adversarial process. So you get a judge and a child expert, psychologist, working together with the family, and they have 4 different tracks. They have a mediation track, so mediator alone, judge and mediator or child expert working together, and then there are 2 other tracks. The final track is if there has to be a hearing, then there is a hearing with lawyers that are involved. But it's a very different type of hearing, and they don't have these massive court cases that we do. So I do think that we have to recollect that children work affects children badly. And for them to be caught up in the court process is a really hard thing for them to experience. So the work that is done outside the court can lend itself much more easily to the involvement of children, child inclusive mediation, for instance, or Dr. Gardner seeing children, that sort of thing, or the work that you're doing can involve the children and allowing them to be heard.
Well, that's absolutely key, isn't it? Because those children grow up and their relationships then are impacted by their childhood experiences. So you're just carrying some of this on into future generations. And if you're more likely to have a relationship that's coloured by your own parents' relationship in a negative way, then that then just keeps rolling forward. So we have to accept at some point that people's relationships ebb and flow. Sometimes they work for a period of time, and then there's an ending. But ultimately, we need people to be able to transition between relationships in a less damaging way, because otherwise, as you say, it's the children of those relationships that then keep that damage, hold that damage, impacts their relationships. And so the cycle repeats. So I think it's really key that we get better at understanding the impact on children and that the children's voices are heard in all of these processes. And I think, as you say, NCDR gives a much better opportunity for that to take place. If you're somebody listening to this and you're in the midst of a breakup and you're wondering, what's my next step? Where do I go? What do I do? What advice would you give somebody if they're right at the beginning of this process, listening to this podcast? What would you say to them?
Only go to court as a last resort. So family court, last resort is the simple message that I would give. Your family issues are your private affair. These are your children. This is your relationship. This is your money. Don't place them in the hands of another person for a decision to be imposed, as would occur if you go to court. Take time to resolve it between yourselves. And if you do, you will hold your head up high at the end of the process because you will have retained control of the things that are most dear to you. That's the message I'd give.
Thank you. But Stephen, where can people find out more about you if they're interested in any of the approaches that you've mentioned?
Easy through looking up Gardner Wildblood, which is the LLP that I work with Dr. Gardner, or 3PB chambers. It's a huge set of chambers. And if you just put 3PB into a search engine, that's it. And you can get in touch with me through there. But Kate, it's really kind of you to have invited me to talk to you. And thank you very much indeed for the work that you're doing and the considerable benefits that you're bringing for the people who are going through such difficult times.
Thank you. Well, I think we're on an NCDR championship together, aren't we? Trying to make sure that this is the preferred route of choice.
It's what I believe in. So this is my third career.
Yeah, down to the bottom of my heart. Me.
Well, you and me together.
Thank you. For separation and co-parenting support, you can visit amicable.co.uk, where you can find our resources and explore the different things we have in terms of help and tools, or you can book a free advice consultation as well. You can find me on LinkedIn, and if you've enjoyed this episode and want to hear more, then please subscribe for updates by visiting thedivorcepodcast.com, or you can find us on your favourite listening platform. Thank you very much indeed for joining me, Stephen. Finally, we'd love to know how we can help more. So please share your questions on divorce, separation and co-parenting with us at hello@amicable.co.uk. You never know, they might be the topic of the next episode. Thank you for listening.